Good morning, everyone. So it is 10 o'clock and we are going to be starting this session. Thank you so much for everyone for joining today. I know it's a nice rainy day and we're happy that you could join us. So today's session is going to be about trusts and taxes, and we've got our experts Kelly Leach and Jacques Blighnout, who have been specializing in this field for quite a bit of time, and they are going to be sharing with us exactly what you need to know about trusts and how to set it up, whether it's the right vehicle for you to invest in property and to use in general in your estates. Just a bit of meeting rules. First of all, I'm going to be handing over to Jacques, but then we will be recording the session. The recording will be shared afterwards, and also we'll be making available a certificate for the attendance of today's session that will be shared with you. Please be on the lookout for that, but it will only be from tomorrow or Monday, depending on our registrations and sending out the mail. So be on the lookout for that email, and we will obviously be sharing that with you. Then just a bit of admin. If you do have any issues regarding the recording or the certificate or something like that, you're more than welcome to email marketing1@stbb.co.za. If you have any queries regarding this webinar and trusts and taxes, you can email Jacques and Kelly at trusts@stbb.co.za. I'll share them in the chat. We'll have them at the end, and we'll also be sharing them on our email after this event. So I'm going to hand over to Jacques. If you've got any questions, you're more than welcome to post them in the chat. We will try and get to all of them at the end of the session. However, if we don't get to them, we'll try and answer them on email to the participants, or send out a general email if there were questions that we could not attend to. So thank you so much for joining today's session. And without further ado, I'm going to then hand over to Jacques Blighnout.
Good morning, ladies and gentlemen. Thank you very much for joining us this morning. Just another housekeeping rule that Leonie forgot to mention. Please don't unmute yourself. I think everybody is muted by the marketing department. And as your mother warned you, when you get an invitation from lawyers, read the fine print. If you read the fine print, you would know that the moment you unmute yourself, we treat this as a consultation, and we'll be obliged to send you an account at the end of the session. I am a director in the commercial department, and Kelly is an associate in our trust and estates department. And if you're in any doubt as to who's speaking, Kelly's the pretty one, I'm the handsome one. So I think let's start the session. I'm going to share my screen here. So if Leonie, if you can just confirm, can everybody see my screen?
Yes, we can. Thanks, Jacques.
Okay. I think, ladies and gentlemen, if we can just start by saying, what is the purpose of our talk here today? What do we want to achieve with this session? And I think just to start off, we constantly get quite a stream of requests from clients to form trusts. And a lot of the time, it's our experience that the clients don't always understand what a trust is or why they would need one. And even our clients who do have trusts, when they approach us for amendments to the trust, we often find that they don't understand the working of a trust, and as a result of that, they can expose themselves to liability and risk. So what we want to do today is just quickly look at what is a trust. This is very high level. Then what are your possible reasons for having a trust? How do you form a trust? How do you amend a trust? We'll look at the role of the trustees. We'll look at the position of beneficiaries. Then we'll have a quick session on just how a trust functions. And then trusts and tax, and really we are just going to touch on that. I think if you talk about trusts and tax, you can probably have several sessions lasting several hours and not even scratch the surface. And then at the end, we'll just look at how do you, in fact, terminate a trust. So the intention of this talk is that if you don't have a trust, hopefully by the end of this talk, you will be able to decide whether a trust is in fact the vehicle that you need. And if you already have a trust, then hopefully you would be able to establish and to find out for yourself, is my trust functioning properly? And do I need to change anything? And what do I need to do? So I think without further ado, let's then just jump in and say, what is a trust? Now, I think broadly speaking, there are two types of trusts: testamentary trusts and inter vivos trusts. Now, testamentary trust is exactly what the name indicates. That is a trust that a testator or a testatrix forms in his or her will. Now, why would one need a testamentary trust? And the most common reason for having a testamentary trust is generally where there are minors that stand to inherit. And then minors cannot hold their own property. And in most cases, if they are cash, then that cash would have to be paid into the guardian's fund until the minors reach the age of majority, which, as you know, in our law today is 18 years. So the way to address that problem is, in the will, you create a trust, and the bequest to the minors will then be left to the trustees to administer on behalf of those minors until they eventually reach the age of majority, or we suggest in a number of cases that that age should actually be slightly higher, 25 or even 30, or it could even be an event. The children finish university, or they buy a house, or they get married. So at that stage, the trust, testamentary trust, will then terminate, and the assets in the trust will be distributed to those beneficiaries, and no longer being minors, they can then become the unfettered owners of those assets. Now, inter vivos trusts, now inter vivos is the Latin term which means during life, in life, is a trust that comes into being by way of an agreement. And this agreement is an agreement between a person that we call a founder or a settlor, and one or more persons that would be the trustees to the trust. And in terms of this agreement, the settlor or the founder would make over assets over to the trustees. They would become the owners of those assets in their capacities as trustees. So they're not unqualified owners, only in their capacities as trustees. And they are then managing and administering those assets for the benefit of the beneficiaries that are stated in the trust. Now, because a trust is a document that's drafted and can last quite a while, you cannot anticipate everything that will happen. So I think one of the first points that you need to be very careful is in the drafting of the trust deed. And here it's important to consult with somebody who understands the drafting of trust deeds, understands the rights and obligations flowing from that, and can anticipate as many eventualities as possible in drafting the trust deed. Now, at this stage, the courts have held that the nature of a trust deed is what we call a stipulatio alteri. We love Latin, our lawyers. Or in plain English, it's a contract or an agreement for the benefit of a third party. Now, in contract law, generally, only parties to a contract can acquire rights and obligations from that contract. So in this case, we have the founder, we have the trustees. They will get rights and obligations from that contract. The beneficiaries, in most cases, won't be a party to the agreement, so they won't acquire any rights or obligations from that agreement. But contract law says that the moment the beneficiary in a contract for his or her benefit accepts a benefit, they become a party to the contract. So in this case, once benefits are distributed to the beneficiaries, or they accept benefits, they now become a party to that contract. And the most important consequence of this, as Kelly will point out later, is that when that trust deed is amended, they now need to be a party to the amendment. Now, there are basically two laws that will apply that you need to keep in mind when you form a trust. First one is the Trust Property Control Act. Trust law in South Africa is dealt with by way of the common law, but the Trust Property Control Act imposes obligations on trustees. And then, of course, in the case of testamentary trusts, we need to look at the Wills Act, because a valid testamentary trust can only come into being as a result of a valid will. So the formalities of a will need to be complied with when that testamentary trust is formed. Why would you need a trust? Let's just think about that. I mean, a lot of the clients who approach us for trusts come to us and they say, well, they think they need a trust. And then once one starts having the conversation with them, it's clear that they don't always have a very persuasive reason necessarily for having wanting a trust. Quite often it is just that somebody told them they need a trust, or they're thinking about doing things. So let's just look at the reasons why one would need a trust. Firstly, it is a tool for estate planning. And how does one do that? If you have a trust and you move assets into that trust, or you acquire assets in that trust, those assets, firstly, do not form part of your estate. So when you die one day, the estate duty won't be calculated on those assets. A trust is a very handy way of creating generational wealth. So that's when the assets and the wealth would go to the following generation. I believe the term that I always use is generation skipping. Kelly told me, informed me, the more modern term is creating generational wealth. And then if that can also, of course, be achieved by a testamentary trust to a certain extent, except that the assets are already in your estate when they are moved to the testamentary trust. The other reason why one would need a trust is, of course, to protect your assets from your creditors, because once the assets are in the trust, they don't form part of your estate, and your creditors cannot get to them. But just note that if you create a sham trust, in other words, it's a trust that you create with the purpose really of deceiving people, the courts can set that aside, and they have set them aside in the past. So your creditors can get those assets. And especially in the case of matrimonial disputes, the courts have held that the assets in a trust can be taken into account when determining the value of a spouse's estate for purposes of determining accrual. So just keep that in mind. Another reason for having a trust is to make income available to somebody who cannot look after their own assets or generate their own income. And there, the Income Tax Act recognizes what we call a special trust. It's also a way that the courts have introduced in road accident fund settlements of making sure that the money that's paid out to an injured person reaches that person at the end of the day. Of course, you can also have a trust for philanthropic purposes, and that is just for a purpose such as saving the whales or picking daisies or something like that. And that trust would then be set up with a very specific purpose, and everything in that trust would be geared towards achieving that purpose. Now, having said, or having given you the reasons as to why you may need a trust or want a trust, let's just look at how assets get into a trust, because this is quite often a stumbling block in setting up a trust. Assets can get into a trust in basically one or two ways. The asset can be donated to the trustees. In such a case, the consequences will be that the person who donates the asset, in most cases the founder, will pay donations tax on the value of that asset. But the trustees then receive that asset unencumbered and become the owner of the asset in their capacities as trustees. And they own it outright for the benefit of the beneficiaries. If the asset isn't donated, then the trustees must buy the asset from somebody. If the trust already has money, then they can pay cash for it and they become the unencumbered owners of the asset. On the other hand, they can also borrow money and then acquire the asset in that way and repay the bank or whoever they borrowed the money from. The founder or the settlor can also sell the asset to the trust and create a loan account. So the trust now owes him or her the money. But that has a consequence, because what has happened now? The settlor has just substituted one asset in his estate, the property, for another asset, the loan. So if the purpose is to reduce estate duty at the end of the day, you haven't achieved that purpose because the loan is now sitting there as an asset. And you're going to have to deal with that asset in your will. There is some advantage to doing that, because at the end of the day, if you put a growth asset, property that will grow in value, into the trust, then at least you peg the value in your estate at the value of the loan, and the growth asset will then grow in value in the trust, and that growth will not be eventually taxed in your estate. However, just remember, if your purpose is to protect your assets from your creditors, that loan account is now subject to attachment by your creditors should they sue you or should they sequestrate you at the end of the day. So from that point of view, one would like to get the asset unencumbered as quickly as possible, and you wouldn't necessarily want to have a loan account sit in your estate for a long period of time. There's also, of course, another very practical consequence, that if you already own the asset, it becomes very expensive to transfer that asset into the trust, if you're founding the trust, because especially in the case of immovable property, you can have capital gains tax, you can have transfer duty in most cases that you have to pay, attorney's fees. There may be a bond on the property which you now have to cancel and register a new bond. So you have the cost of bond registrations. And even if the bank agrees to substitute the trust as a debtor, the substitution costs at the end of the day won't necessarily be much cheaper. So keep that in mind. It's far better if you set up a trust to actually acquire the assets in the trust from the word go. Just another word of caution on transferring your property that you live in into a trust. Remember, you've got the capital gains tax exemption on your primary residence. The moment you transfer that into a trust, you lose that primary residence exemption once the property is in the trust. So you need to be very sure that at the end of the day, it's going to be worth the value of losing that exemption. Now, if we look at the formation of a trust, we're dealing with an agreement. So the normal rules that apply to agreements will apply to the formation of the trust. And the first one that you need to look at, of course, the parties to the formation of the trust, as we said, will be the donor and the trustees, is their contractual capacity. So they cannot be minors that are not assisted by their parents or guardians. They cannot be of unsound mind, because people who are of unsound mind cannot validly conclude contracts, and they cannot be unrehabilitated insolvents. If one of the parties forming the trust is a company or a close corporation or perhaps another trust, then you need to ensure that the founding documents of those entities allow them to do such a thing as forming a trust. As you know, any agreement can either be an oral agreement or a written agreement. Exactly the same way you can have an oral trust. Our law recognizes oral trusts, but they are of limited application. And the moment any arrangement between those trustees is reduced to writing, becomes a written trust subject to the provisions of the Trust Property Control Act. The most important section of the Trust Property Control Act for those purposes, Section 6, which says that the moment there's a written instrument of trust and a trustee is appointed in terms of that written instrument of trust, then the master needs to authorize the trustee to act validly. Please note, a trust is not a person, like a company or a close corporation is a person. The trustees act jointly. They are the joint owners of the property. And I think if you register property in the deeds office, you register it in the name of the trustees for the time being of such and such a trust. That's how they cite it in court as well, or in their names, in their capacity as trustee. However, there are certain acts that recognize trusts as persons: the Income Tax Act, Value Added Tax Act, the National Credit Act, Companies Act to a certain extent, and the Consumer Protection Act. So just be aware of that. I'm going to hand over to Kelly now, who will take you through the requirements to register an inter vivos trust. Kelly, over to you on this one here.
Thanks, Jacques. So once you've made your decision to now create the trust, the Master of the High Court as well as SARS has different requirements that they need you to fulfill in order to have that trust registered. The Master of the High Court requires various documents in order to register a trust. The first document being the trust deed. As mentioned earlier by Jacques, this is an agreement between the founder or the donor and the trustees to create a structure, or what we refer to as a special purpose vehicle, for the benefit of a third party. A trust deed must make provision for how the trust is run, who will benefit from this trust, the powers bestowed upon the trustees, the rights provided to all of the parties involved, as well as the exemption of security. And what security is, it's an insurance that is paid by the trustees to the Master of the High Court to ensure that they act in the best interest of the trust. However, this is based on the value of the assets in the trust and is often an unnecessary expense incurred both by the trust and the trustees, which can be avoided by making provision for its exemption in the trust documents. The master further requires an acceptance of trusteeship from each of the trustees, which provides whether the trustee is related to any of the other trustees or beneficiaries. This is to ensure they're not related parties, and if they are, that it is declared. If the trust is a business family trust, meaning it has business operations within the trust, an independent trustee must be appointed, in which a sworn affidavit must accompany the acceptance of trusteeship. Please note that there are persons that are disqualified from acting as trustees, and these are persons that have been convicted of an offense involving dishonesty and deception, declared insolvent, ever declared mentally ill or incapacitated, are disqualified as trustees. More recently, as of the 1st of April, there have been some amendments to the Trust Property Controls Act, and it extends the disqualification of who can act as trustees and who cannot. And the definition has now been extended to delinquent directors. This amendment has been made to Section 6 specifically, and it provides that a person disqualified from being authorized as a trustee if the person has, one, been prohibited to be a director of the company, or declared by a court to be delinquent in terms of Section 162 of the Companies Act, or Section 47 of the Close Cooperation Act, or was prohibited in terms of any law to be a director in a company in South Africa. Further documents required are a registered form, which the master's office uses for data capturing purposes, as well as a beneficiary's form, which provides the details of the beneficiary, as well as their guardian in the instance that the beneficiary is a minor. Beneficiaries may also refer to a class of persons. Say, for instance, you've got a trust for the benefit of specific groups of persons, as well as entities in the event that you have perhaps a company or another trust as the beneficiary of this specific trust. The documents must be accompanied with a certified copy of each of the trustees' IDs. And where a nominee of an entity is the trustee, that entity's founding document must accompany the application. So say, for instance, you have an independent trustee, and perhaps that trustee is your accountant or your attorney, their founding documents would need to accompany that application. For example, the memorandum of incorporation for that entity. The application would also need to be accompanied with a proof of payment, and this payment is made to the Department of Justice and Constitutional Development. If all the documents are in order, the master takes about 6 to 8 weeks to register the trust and issue letters of authority. However, this is completely dependent on the work volumes at the master's office, and more recently, they have been trying to digitalize their systems, which has made it extended this waiting process quite significantly. But once your trust has been registered with the master and you've now got your trust registration number, the trust would then need to be registered as a taxpayer with SARS, regardless of whether the trust will be receiving an income or not. It is advisable to obtain the services of a tax practitioner to attend to the registration, as it can be quite time consuming and you would like the application to go through on your first try. And in the event that you are using a tax practitioner, SARS will require the letters of authority which was issued by the master of the High Court to say that your trust has now been registered, as well as a copy of their trust deed, because of course they will need to identify all the persons to their trust. You would also need to elect what we call a main trustee, and this will be the person that will be registered as the representative taxpayer at SARS. And what you would need to then supply SARS with is either a copy of that main trustee's identity documents, a valid driver's license, or a temporary ID for that trustee. You would also need to provide a trust resolution stipulating or confirming the appointment of your representative taxpayer, again, that main trustee that we spoke about of the trust, a power of attorney or a letter of appointment indicating that your tax practitioner has the authority to register this trust with SARS on behalf of the trust, a copy of the identity document of that tax practitioner, a proof of address of the trust, as well as proof of address for your representative taxpayer, again, that main trustee, as well as one for your tax practitioner, and of course, an application form which should be completed to, of course, finalize that application with SARS. But now that your trust is up and running, perhaps it's been a month, perhaps it's been a year, perhaps it's been a decade, and the trust needs to now make certain amendments in order to keep up with the legislation, in order to keep up with times, in order to keep up with the needs of the trust, or perhaps the entities within the trust. You would then need to be able to make amendments to that trust, which is why it is important when you are initially creating that trust, to ensure that that trust provides for the manner in which the deed can be amended. This is equally important for testamentary trust as it is for inter vivos trust. A testamentary trust, like Jacques spoke about earlier, a trust that is made in terms of a will, only comes into being on the death of the testator or the testatrix. And that stands to reason that he or she can no longer amend provisions of the trust created in terms of a will after the date of death. It is therefore It will therefore not deal with the manner in which the trust would need to be amended. On the other hand, for inter vivos trust, the position is that if the founder is alive and the trustees, the founder and the trustees can amend the trust deed. This is also the common law position. So where a trust is silent on how to amend a trust deed, this still can be done by the founder and the trustees. But in the event that the founder has passed away and the trust deed is silent on the manner in which the trust can be amended, you would need to look at the Trust Property Controls Act for assistance on how to amend their trust deed. And in this instance, you would look specifically at Section 13 of the Trust Property Controls Act, which allows the court to delete or vary any provision of the trust deed, make any order that the court deems just in respect of any provision, including an order whereby a particular trust property is substituted for a particular other property, and an order ultimately terminating the trust. However, the court can only make such an order where it finds that the instrument contains a provision which brings about consequences not foreseen by the founder of the trust, and which one hampers the achievements of the objects of the founder, or prejudice the interests of the beneficiaries, or was in conflict with public interest. And for this reason, it is very important that the trust deed initially makes provision for how it can be amended, or else you do have to go the route of court. The Trust Property Control Act provides that a copy of the amendments or amended trust deed, if the amendments are quite substantial, must be filed with the Master of the High Court in the manner in which the trust deed provides. And as Jacques said earlier, if any of the beneficiaries have received a benefit prior to the amendments or have a vested right in the trust, they must be a party to the amendments. The master will further require the amendment form to be completed for data capturing purposes. This requirement to file a copy of the amendments with the master is an administrative requirement and not a requirement for the validity of the amendments. The parties can therefore proceed in accordance with the amended trust deeds provisions, even if it has not yet been filed with the Master of the High Court. However, please note that should you use the trust for BEE purposes or a BEE structure, the BEE Commissioner wants to see the Master's filing slip or confirmation of the deed of amendments before they will give effect to that amendment. Okay, back to you, Jacques.
Thank you, Kelly. Oh my goodness, what's happening? Yes. We now get to trustees. Now, trustees are the persons appointed in terms of the trustee to manage the trust property on behalf of the beneficiaries. Section 6 of the Trust Property Control Act makes it very clear that trustees can only act once they have been authorized in writing by the Master of the High Court to act. Now, you need to distinguish between the appointment of the trustee and the authority to act. The trustee is appointed in terms of the trustee, often by the founder, or the trustee can provide that the other trustees can appoint new trustees or assume trustees. But even if that trustee is validly appointed in terms of the trust deed, he or she cannot act until the master issues letters of authority. It's very important, ladies and gentlemen, that in the trust deed must properly provide and regulate the changes in trustees. When will somebody be allowed to leave? What is the process for the person not being a trustee anymore? How do you appoint a new trustee? All of that must be set out in quite a bit of detail in the trust deed. Otherwise, you could have some problems. There are, I'm not going to deal with them now, but there are certain cases where the master can step in and remove trustees from office, and the master has that authority in terms of the Trust Property Control Act. Trust deed must provide for the circumstances in which a trustee ceases to act as a trustee, and that is quite often, until the recent amendments to the Trust Property Control Act with delinquent directors, that was not the position in the Trust Property Control Act, and you had to regulate that in the trust deed itself. And often, if the trust deed is set up for a specific purpose, you would want the trustees to be aligned with that purpose. And if something should happen that a trustee no longer agrees with that purpose of the trust, or may leave the country, you would want the mechanism to remove that person from his office of trustee. Then, just an aside here, I often see in trusts that they provide for what is called alternate trustees. And I think that comes from alternate directors in the company. And the purpose is a laudable one, where a trustee wants to have somebody around to act in his or her stead when they are not there. I don't think that such a creature can properly exist. So if it is in your trust deed, I think just pay some attention to that clause and see whether it can function. Because as we said above, a trustee cannot act until he or she is authorized by the master. So if you appoint an alternate trustee, if that person hasn't received letters of authority from the master, he or she cannot act as trustee. May be able to sign documents, but can't act as a trustee. But once that person has received letters of authority, then he or she is a trustee. And the common law relating to trusts requires that trustees must act jointly. That means all the trustees. So if a trustee is now not acting because he or she is an alternate trustee, I think that does create a problem. It can be regulated in the agreement, but I think the drafting required is probably more technical than a lot of the clauses that I have seen. Being a trustee is an onerous position, and I think a lot of people create trusts or consent to acting as trustees without knowing how difficult it can be. You owe quite a high duty of care to the beneficiaries of the trust, and you must always act in the best interest of those beneficiaries. If you do not act in the best interest of those beneficiaries and they suffer damages, they can hold you liable, either the body of trustees or individual trustees. And it's our experience that we are seeing more and more cases of people trying to hold trustees liable. So before you accept appointment as a trustee, keep that in mind. The recent amendments to the FICA Act has also now created a creature called a beneficial owner, and the trustees are obliged to keep a register of the beneficial owners. And just to give you an indication, if it's not done properly, then trustees can be held criminally liable with a maximum prison sentence of 5 years. And there's also an administrative fine or penalty of up to 10 million rand that can be imposed. So think twice before you accept the position of trustee. Now, let's just talk about the beneficiaries quickly. Beneficiaries are usually set out in the trust deed, and they will usually be set out either by name or by class. So the common descriptions that one would find in the trust deed is my wife, or my husband, or my spouse, or the children born of the wedding or the union between the founder and the founder's wife. And then the trustees can also be given the authority to elect certain beneficiaries from that class to benefit at the end of the day. The trustees can then also, if a class is identified, usually in a trust that's set up for a special purpose, identify beneficiaries within that class. For instance, the scholars in grade 11 or 12 who display a specific aptitude for mathematical sciences or something like that. Now, what interest does a beneficiary have in the trust property? If the trust is a fully discretionary trust, in other words, the trustees have the discretion to decide firstly who will be the trustee, and if the trustees have been set out in a class or in a group, who within that class or group will benefit and to what extent, then those beneficiaries really only have a hope that they will receive something we call in law a spes, the Latin for hope. So they only have a hope that they're going to get something, and nothing more than that. It doesn't form an asset in their estate, cannot be attached by the creditors in their estate. On the other hand, if the trustees have vested assets in beneficiaries, the asset may not yet be transferred to the beneficiary, but the beneficiary now has a personal right against the trustees in that trust to claim transfer or delivery of that asset into his or her name, whereafter they will then become the owner of the asset. You also have a case where the trustees may very well have transferred assets to the beneficiaries already, and they are now the owners of the asset, but the trustees still administer those assets. Then the beneficiaries will have a personal right against the trustees to properly manage those assets for the benefit and in the interest of the beneficiaries who are now the owners of the assets. The recent amendments that I spoke to on the FIC Act has now created this creature which really comes from Anglo-American law, a beneficial owner. And that is all done to determine who benefits from money laundering at the end of the day. The problem is that it has now introduced a concept that's foreign to our law into our trust law. So when setting up a trust deed and drafting a trust, be very careful what terms are used. Because to give you an example, if you should use the term beneficial owner in the trust deed, the Act has now described beneficial owner as including the trustees and the founder. And clearly, from what we've said so far, that cannot be. So we're not sure how this is going to play out in the future, but be careful in the drafting of those trust deeds. Now, let's look at the functioning of the day-to-day functioning of a trust. And I think here I just want to distinguish between two concepts, namely capacity and authority. Capacity is whether the trust or the trustees can do something. Do they have the power to, in fact, do it? Now, the first occasion where the trustees would not have the power is where the trust deed specifically says you cannot do something. In a trust that owns immovable property, if the trust deed says the trustees cannot bond this property, cannot register a mortgage bond over the property, then clearly any action on their part to bond this property would have no effect because they do not have the power to do that. In company law, that is called where the company acts ultra vires or the directors act ultra vires, but that is specifically regulated in the Companies Act. Our courts have held where the trust doesn't have capacity, the trustees cannot act. Their acts are void. A second one, and this is one that creeps up on you, is where the trust stipulates a minimum number of trustees, let's say 3 trustees, and then a trustee dies, for instance, and a new trustee is not appointed. The courts have now held that that trust does not have capacity, and anything that is done by the other 2 trustees will have no effect. So it's very important that, once again, the trust deed must regulate what will happen in a case like that. Can the remaining trustees act? And if they can act, what can they do? Can they only appoint a new trustee, or can they, for at least a certain period, perform valid acts pending the appointment of a new trustee? Now, authority, on the other hand, is determining whether trustees are actually acting the way they should be acting, and this assumes that they have the capacity to act. And here the golden rule, according to the common law, is that trustees must act jointly. They are the joint owners of the trust property, and the common law relating to joint ownership of property is that the joint owners must act jointly. Does that mean that the trustees must always sign all documents? In other words, if there's a deed of sale and you have 7 trustees, must all 7 sign the document? No. What it means is that, acting in terms of the trust, the trustees must act jointly. If that is passing a resolution, and that is a written resolution, then yes, all 7 trustees must sign that resolution, but they can authorize one of their number to act on their part. So when you are dealing with a trust, please scrutinize that. Can any unauthorized act be ratified? The law is not always clear on that. It's quite clear that where the trustees acted without capacity, it cannot be ratified. But in other cases where they just didn't carry out the provisions of the trust deed properly, but they were still within their capacity, there seems to be a move towards allowing ratification of those acts. Perhaps just one thing that I can mention here, for all the property practitioners that are listening: you cannot act on behalf of a trust that still has to be formed. In our law of agency, you cannot act on behalf of a non-existent agent. Trust doesn't exist. The trustees have no authority, or nobody has the authority to act on behalf of a trust to be formed. Now, if we look at trusts and tax, and I'm really just going to skim over this. A trust is a person for purposes of tax, both income tax and VAT. Trust is, in terms of the Income Tax Act, a provisional taxpayer, and therefore has to render returns in August and February of each year, and a final return. If a trust makes supplies or goods in terms of the VAT Act, it needs to register for VAT if it exceeds the threshold, and of course you need to render your VAT returns. If the trust has employees, it needs to register as an employer and render those necessary returns. Now, just note that a trust pays income tax at a flat rate of 45%. Luckily, we have in our law what we call the conduit principle. And in terms of the conduit principle, one can distribute income in terms of Section 25, capital B of the Income Tax Act, and capital gains in terms of paragraph 70 of the 8th schedule to beneficiaries, where it can then be taxed at their rate. There are certain requirements you need to adhere to, but if you do that, you can quite clearly see how beneficial it can be. For instance, in a capital gain that's distributed, the inclusion rate in a trust is 80%, taxed at 45%, where if it's distributed to an individual, your inclusion rate drops to 40%. And even if the individual's marginal rate is 45%, you're literally going to pay half the tax. If you distribute interest income, a trust will pay income tax on that interest from Rand 1, whereas the individuals will be able to use the exemptions that they have in terms of the Income Tax Act. I think 23 odd thousand Rand in the case of individuals under 65, and 32 or 33 if you're over the age of 35. Just note that and let's just look at the anti-avoidance provisions from the estate duty point of view. If the founder has retained control over those assets and treated them as though they were assets in his estate, the law is probably going to treat him the same way when it comes to tax. So in estate duty, you could have had this elaborate scheme to take the assets out of your estate, and then you treat them as though they're your assets. For estate duty purposes, they will be treated as assets in your estate and will be subject to estate duty. Similarly, Section 7 of the Income Tax Act has certain anti-avoidance and attribution provisions where income earned in the trust can then be added back into the income of other people. And Kelly, I think I'm going to hand over to you now for purposes of dealing with the termination of a trust.
Thanks, Jacques.
Kelly.
Just realized I still muted. Thanks for that. So now we've gone through the entire process of the trust. You've had this trust, but it now comes to the point where this trust needs to be terminated. And a trust can be terminated in a number of ways. The first trust, being a testamentary trust, will terminate if the purpose for which it was created is fulfilled. So let's say, for instance, you've used this testamentary trust for estate planning purposes to the extent that you perhaps had a minor child that inherited in terms of your estate, and perhaps you say that this trust must be in existence until such time that they reach 18, maybe 25, maybe 30. Upon that child attaining that age, the trust will then be terminated with the Master of the High Court because it has now fulfilled its purpose. In the same way, an inter vivos trust can be terminated once it has achieved its purpose. Let's say, for instance, you've got this trust running for the until the founder has passed away, in which case, upon the founder's death, that would trigger the termination of that specific trust. Other trusts have provisions for the trust to be terminated at the discretion of the trustees, in which case the trustees will pass a resolution to terminate the trust. And this usually will happen once the capital in the trust has been distributed to the beneficiaries that are entitled to that capital. The requirements for terminating a trust is firstly with the Master of the High Court. Once the trust has run its course as per the trust instruments, the trust must be terminated with the Master of the High Court and, of course, SARS. The Master of the High Court requires the return of the original letters of authority, and this was issued to you when the trust was registered. Alternatively, when you amended who the trustees were, you would have been issued with new letters of authority. However, in the absence of those letters of authority, because often life happens, you lose certain documents, you can write an affidavit to the Master of the High Courts, providing that after diligent search, you could not find the original letters of authority, and you can ask them to dispense with the condition of providing them with the original letters of authority in order for them to terminate the trust. The Master further requires a resolution adopted by all of the trustees in favor of terminating the trust. The bank statement reflecting a nil balance. The proof that the beneficiaries have received their benefit, and original affidavits by each of the trustees providing that they have confirmed that the trust has been divested of all of its assets, meaning that there is nothing left behind, like a investment held somewhere, that everything that they can attest that everything has been indeed finalized. Once the master has satisfied itself that all the conditions have been met, they will issue a letter confirming the date of termination of the trust. But of course, what must happen at SARS, at the Master of the High Court, needs to also happen at SARS. And once the trust has been terminated with the Master of the High Court, the trust must be deregistered as a taxpayer. SARS requires that letter from the master, providing the date in which the trust was terminated, including the minutes of the meeting in which the resolution was taken to deregister the trust. Thereafter, SARS further requires the distribution list and financial statements until the termination date. Only upon receiving all these documents can you say you have gone through the entire trust process and you have now finalized that trust. Jacques, back to you.
Thank you, Kelly. That brings us to the end of our discussion. And what can we conclude from this? I think we will be very happy if, after our talk this morning, you have enough information available to decide whether you do need a trust, and if so, how you would like to structure that trust. And if you already have a trust, to determine whether your trust is being administered properly. I think one thing I would like people to take away from the talk is a trust can be a very, very handy and flexible vehicle in estate planning and in protecting your assets. However, it can be very expensive to set up a trust, to move assets into a trust. And if the trustees aren't fully au fait with the obligations placed on them, I think they do expose themselves to risk, and they need to be very careful. So from Kelly and myself, thank you very much for joining us this morning. It looks, Liani, as though we're going to battle to get some questions in, but thanks very much for taking time to listen to us. And I think some of these topics that we discussed this morning will definitely warrant, I think, talks on them that can go into more detail.
Thank you. Thank you so much, Jacques. Thank you, Kelly. Jacques, if you can perhaps share your last screen just with your contact details. I know we're at the end of the session, but I do think that there are quite a few good questions. And I just wanted to raise these two that Mark Edwards had posed. Is, first of all, what is your view on using a usufruct or bare dominium to transfer fixed property into a trust? Any specific advice to maximize the efficiency of the transaction, and is it something that STBB can assist with?
Yeah, look, it's something that STBB can assist with, but you always need to be very, very careful in using usufruct, because what a lot of people forget in using a usufruct is, yes, you do save transfer duty initially because you calculate the value of the property on the value of the bare dominium. But if that usufruct terminates one day, then there are tax consequences on the termination. So I would think that, yes, it can be done. And yes, it will definitely reduce the exposure to transfer duty at the beginning, but be very careful on where it ends. And because the usufruct would generally be retained in favor of a person who's also going to be a connected person to that trust, SARS will scrutinize the tax consequences of that quite carefully.
Thank you. And then there was one question regarding the implications of a non-South African resident setting up a trust in South Africa while living abroad. what are the implications and whether it's possible, and the costs and etc. I don't know if you can answer all of that in one answer, but maybe just give a bit of guidance on it.
Yes, non-residents, I think, can set up trusts, but it could very well then be that the trust would be an affected person for purposes of exchange control. And I think just something that we can mention here is that if the beneficiaries in a South African trust should become non-residents, the 8th schedule treats that as a disposal of assets. So the trust is then subject to scrutiny at that point, and capital gains can be triggered. Yes, I think it's possible, but you need to be very careful, and you will have to interact with both SARS and the exchange control authorities in setting up a trust.
One of your trustees will also have to be based in South Africa. And if any of the other trustees are based outside of South Africa, you would also need a South African domicilium for each of them.
And they will also have to be authorized by the master in terms of so even a foreign trust, if the trustees want to act here, Kelly, I think the master needs to
They must have authorization.
Yeah.
Thank you so much. I think the last question that I wanted to address, and I think this is quite a frequent question, is what are the unique features of a business trading trust, and any thoughts on transferring shares in my business through such a structure for purposes of tax efficiency?
Sure.
So I think they're just referring for asset share transfers, which
Look,
I know is quite a big question that we usually get.
Yeah, look, at the end of the day, a business trust, the way they usually differ from family trusts is that you create groups within that trust that will have specific benefits, very much like shareholders in a company. So yes, you can set that up. I personally do not like the vehicle of business trusts. I think companies are far more structured for business purposes. Holding shares in a trust, that's a common holding that one has. And once again, you would do that, I would think, for estate duty purposes, because the growth in value in those shares as the company grows would then take place outside of your estate. But remember that any dividend distributions into the trust would then be subject to dividends withholding tax of 20%. So a trust will not have the benefit that a holding company would have, for instance, where dividend distributions to a holding company would be free of dividends tax.
Great. Thank you, Jacques. I think, Mark, I hope you're still on, but if that answers your question, it sounds like you're going to have to set up a further consultation to structure your business trust or company, however it's going to be. But I think that is all that we have time for today. So, Jacques, maybe you can stop sharing, or I can.
There we go. I'm always amazed
So, yes,
when I can actually manage this.
So thank you everyone for joining us today on this session. I hope you enjoyed it. I hope it shed some light on trusts and how you need to set it up and what you need to know, and also that you have the contact details of our professionals to really help you with the setting up of your trust and structuring your assets to the best possible in the best possible way. So thank you so much. We'll please look out for our email regarding the recording as well as your certificate. And I would like to also announce that we will be having an AI series this coming month in June. So please look out for the invite. I've shared the details in the chat. It's going to be all about what you need to know on AI, whether it's really going to replace your attorney, and how it can benefit you in your day, and what your company needs to do to steer you in the right direction. So please will be on the lookout for that. You can also follow us on our social platforms where we will be posting that as well, and you can have a look for that as there. So thank you so much for everyone for joining us today. I hope you have an amazing day, and I hope to see you in our next webinars.